All right, everybody. Welcome to the collective. If you're just now joining us, this is the Creative Finance Collective. This is where we get together, professionals in the space of creative finance, to discuss real estate and creative finance issues. With us today is so I'm Andy Fowler. We've got Alan Seschker in Texas, Drew Jenkins in Georgia, and we've got Sean St. Clair appearing out of Wisconsin. So we're going to take questions that you have. And we'll be here for about an hour or until we stop getting questions. So it's important for you if you're wanting to engage with the discussion and keep us going to discuss the topics that we get questions from you. One other note: we've got a barcode at the top of the screen. That's for the INREM podcast. If you're watching us from Facebook or another platform, you can go to scan that barcode, and that'll take you to YouTube, which is kind of our the best place to view our content. How's everybody doing today, guys?
Doing well, doing well.
Good. As we're waiting for some of the questions to come in, I wanted to set the stage on a couple things. I'm just pulling it up. Some of the news from this last some of the news in the last week, as you probably all recall, the Fed or they had their most recent CPI data information, and of course inflation didn't go the way that they wanted it to. Inflation has started to creep back up, and we're seeing inflation in all sorts of areas, but I thought this was interesting, and this was as of today. The average rate on a 30-year fixed mortgage in the U.S. rises to 7.43%. In fact, I think at one point today it got to 7.5, so 7.5. That makes it, I think, the second or may make it the second or third least affordable month on historical record to buy a home. This means that a monthly mortgage payment on a $500,000 house with a 20% down payment, I add, is $3,500 a month. Meanwhile, the median U.S. home is now selling for a whopping $417,700. Who's still buying a home? Well, I have an idea. The people that are wanting to buy a home are wanting to do it in using creative finance because creative finance really thrives in a high interest rate environment. In fact, Sean and I we're on a podcast today with a gal, Eileen Brown, who works in title, and she was talking about doing creative finance wrap transactions in the 80s, 90s, and at a time when, I think in the 80s, at a time when I think she said a government loan was at 18% and and a regular private loan was at 20%. Who knows if we're heading that way, but that's the conditions that we find ourselves in. All right. So let's get to a couple questions. Sean, we have a question here. I'm going to read it out. But I know I bring you up, Sean. We had a couple questions on the collective too. So, and you wrote some of those down, so we can address them as we go. Why don't I address this first question we got? Is a sub 2 a breach of the DOT, of the deed of trust? Or if you're not in a deed of trust state, a mortgage, would it be a breach of the mortgage? But is a sub 2 a breach of the deed of trust?
Well, if you look at the language of the Fannie Mae Freddie Mac deed of trust, you'll see that it uses the term option all throughout. And so, and it uses the word may. May accelerate or call the loan due. And when I read that, my takeaway from that particular clause is that it is not a immediate breach, but it gives the lender an additional contractual right that they didn't have prior to the conveyance of the property to a third party. Basically says, hey, if you're going to do this, then we now have this right. But it doesn't actually prohibit it. It just basically says, should the borrower do this, then there is a additional contractual right that comes in.
What if it says shall? Because the FHA due on sale
Right.
clause is shall versus may. Does that change your answer?
Well, there was a reason I chose the Fannie Mae Freddie Mac. No, so FHA is it does say shall. So first, the lender shall. I mean, so if they choose to, they're going to, or they are supposed to. And I believe the word shall is in there because FHA has policies. It's ensuring the deed of trust, and so it's basically, telling the lender, you shall do this. You shall invoke or accelerate the debt. So I don't know that it's a breach per se, because it still creates a right in the lender to accelerate. It doesn't say anything about it being an actual violation or breach. It just says, in fact, let me look.
I'm not even certain it rises to a level of a default.
Yeah, I don't know that it does. I'm gonna. But here's one thing about the FHA due on sale. If you look at the FHA due on sale, the one thing that it does not prohibit, it does not prohibit a long-term lease with an option to purchase. Now, that doesn't help you guys in Texas. I get it.
No.
But outside of Texas, it does not prohibit that. There's no language in there prohibiting it. Do you have a copy of the FHA due on sale in front of you, Alan? I'm looking my copy here.
I do.
Do you see where it would prohibit a long-term lease?
No, it doesn't have that 3-year specification.
No, it doesn't. You could lease the property for 30 years under an FHA and not violate it with an option to purchase. Because I don't even see where an option to purchase falls within that provision. It's very short. It's like 2 paragraphs, not even 2 paragraphs. It's like 2 sentences. It's a very short due on sale clause. Why don't you read it? What does it say? Don't go into the mumble jumble at the very end as far as qualifying.
Yeah, just lender shall. So lender shall, if permitted by applicable law, including the Garn-St. Germain Act, and has with prior approval of secretary, require immediate payment in full of all sums secured by the security instrument, if all or part of the property is sold and property not occupied by purchaser or grantee. So, I mean, I think it's a very simple little due on sale clause.
Right. And if you notice, it doesn't say that the borrower shall not. It doesn't say that it's a default. It just says that they shall if these 2 conditions exist.
Yeah.
And one of the conditions is not a long-term lease with an option to purchase.
I've spoken earlier about what I call consumer wraps and getting out into the mainstream, and you'll find allegations from brokers, not allegations, but we'll call them opinions from brokers and agents or what have you, that says, it's just not ethical because you're intentionally going against the contractual agreements of that loan they provided. And I've bounced back and forth as to whether I agree or disagree with that from a very high level esoteric standpoint. And I guess I haven't come up with an answer yet. I put that out to y'all.
So I know that one of his things is talking about efficient breach, right? Sometimes depending on the circumstances, the better course of action, whether that's something that lawyers get in trouble for all the time, right? Is it legal or is it moral? They're not necessarily the same thing, right? And so in some circumstances, obviously breaching a contract is going to be the moral, the right moral thing to do. And in other cases, it may not be. So obviously lay people tend to conflate the two things. But I agree with Sean that, it can be a very efficient way to breach, just like when you go to your lender and you ask them for a short sale. Right. I mean,
Yeah.
it's the same thing. You're not going to pay them back in full. You're going to them saying, look, I'm going to breach this contract. Right. The question is, are you willing to play ball and get something, or are you going to get nothing or less? Right. And that really is kind of, I think, the idea behind it.
Well, there's two ethics opinions. There's one out of Virginia that I'm aware of, asking whether or not attorneys can be involved in subject to transactions, and whether or not the attorney needs to notify the lender of a breach of the deed of trust, if that's their responsibility. And let me pull it up real quick if I can find it. Do not sell. So it's Virginia State Bar Ethics Opinion 471. And it's a real simple one paragraph. And then the more comprehensive one is actually out of Illinois. It's an Illinois State Bar Ethics Opinion 728. And that one went into a lot of detail. And basically that attorney there was advising his seller clients of the nature of a wrap transaction or a subject to transaction, and advising them to actually do it, and then preparing the documents. And when approached, he said, and I plan to continue to do it. And so the Illinois bar looked at it and said, okay, well, no, that's not an ethics violation. And what they said was basically, as long as this attorney is giving full disclosure to the clients of the consequences of, they use the term breach, but the consequences of breaching, and the client makes a decision based upon informed consent to breach, we're okay with that. In fact, as Drew was saying, they basically said, I'm not going to quote it word for word, but the economic survival of the client may very well depend upon them breaching the contract. That's basically what they said. They went into an efficient breach argument. Now, what they did say, and I think this is very important to keep in mind, is because, there's some loosey-goosey stuff that goes on out there that we need to be very careful with. They did say, hey, look, but if an attorney knows that their client is entering into a contract with the intent to breach, they cannot be involved because that is fraud. I agree with that, actually. That the idea that like, hey, I'm going to enter into this contract with the intention to breach, that's a no-go. And so, a good example of that in the subject to world would be like the straw borrower, right? You get somebody to take out a loan just so you can acquire it subject to, right? Or you get them to do a loan modification or a forbearance or things like that, knowing that they're just going to breach that agreement. To me, that's problematic. But as far as, you come in after the fact, the contract's already in place and you're going to be involved in the transaction, I think efficient breach is the answer. I have a few more things I want to talk about on this topic, actually. But I do want to Drew's point where he talked about short sales. It's funny, these same brokers that I used to do a lot of short sale work for, they're the ones telling me, oh, no, subject to, wrap, that's not legal. You can't do that. And I'm thinking, wait a minute, you were like the short sale queen or king. Like you were all about efficient breach, not too long ago. And so I do think it's funny that, a lot of the same brokers and agents that were real, into the short sale stuff are now like, oh, no, you can't do it this way. It's like, wait a minute. But so Utah, the Utah Administrative Code, which is basically the commissioner's rules governing licensees in Utah. there's actually a provision in their code for real estate agents on the disclosure to the parties, the conducting of wrap transactions where that will result in a breach, and it even uses that, or a violation of the deed of trust, and what their ethical standards are in that transaction. And basically their requirement is that they have to make sure that the buyer, seller, and the other agent is fully aware of the risks and nature of the transaction. But so it's Utah Administrative Code R162-2F-401A. That basically allows agents in Utah to do wraps or subject to transactions as long as everybody's informed of that. The other thing, and I'll bring this. Let's see if I can share my screen so you guys can see this. Let's see if I can pull this off here. So you'll see here, I got this right from the IRS's website, and the font is small, so I'll blow it up for you. So basically on the IRS website, there's this hypothetical on when can you claim mortgage interest deduction. And in the hypothetical, basically, it was a wrap transaction where they had a mortgage. I mean, this is from the IRS's website. Like, it's right there on their website. So Beth had a home subject to a $40,000 mortgage. She sells it for $100,000 to John, who takes it subject to the $40,000 mortgage. Beth continues to make the payments on the $40,000 note. John pays $10,000 down and gives Beth a $90,000 note secured by a wraparound mortgage on the home. But for some reason, Beth doesn't record or otherwise perfect the $90,000 mortgage as required by state law. Therefore, the mortgage isn't a secured debt, and John cannot deduct any of the interest he pays on it as home mortgage interest. So why would we have the IRS giving us this hypothetical if subject to was fraudulent or illegal, right?
Right.
The funny thing is, you mentioned that is subject to
Yeah.
wraparounds are fairly common in certain commercial circles, right? Like it's expected that, the borrower gets a little bit in trouble and, they pawn it off to somebody else. I just use pawn it off, but they transfer it to someone else and the lender's still in the deal and, they're ready to play ball. So subject twos don't have this stigma outside of these normal resi transactions, because in the commercial world in fact I know people who that was their entire business model for a few years, was they have much better credit, right? And so they would go get the loan and then they would sell it subject to, and of course they're still in the middle just like your sellers are. And that was the entire business model, was to borrow it 4 or 5 and lend at 8, and they're just capturing that spread. And of course it's commercial, they're very large and sophisticated. If they needed to take over the asset again, that's not a problem for them. So it's just funny, the difference between the residential world, right? Everyone's worried, is this breach? And in the commercial world, it's like, oh yeah, that's how I make all my money, is by doing subject twos and be literally setting yourself up to be the middleman.
And then finally, at least here in Wisconsin, I couldn't find a similar case in Arizona, but in Wisconsin, we actually have a decision from the Court of Appeals called Schultz versus Midwest Properties or Props of Shawano LLC, which is an interesting case. Basically, it was a performance note and deed of trust for a subject to transaction, and the buyer stopped paying. So the seller went in and foreclosed under the performance mortgage. I think I said deed of trust. We have mortgages here. It was a performance mortgage. Seller went in to foreclose on the performance mortgage, and the buyer came out of the woodwork and made evidentiary objections to the admissions of like mortgage statements as proof that payments hadn't been made. And there was a whole like circus around that, and finally the court ruled in favor of the seller on their foreclosure action, allowed them to foreclose. But Chase was the lender, and Chase knew nothing. Even the court acknowledged Chase wasn't even involved, doesn't know anything about it. All that was happening was the buyer wasn't making the mortgage payments directly to Chase, and the seller found out about it, and then they foreclosed under the performance note. And the court allowed the seller to foreclose, but nowhere in the decision did the court say, oh, well, you guys shouldn't even have done this. This is, unethical. This is wrong. This is a violation of Wisconsin law. Any of that. They basically just looked and said, okay, yeah, this is what you did. You did a performance note and performance mortgage, and you're allowed to, foreclose. So to me, there's enough out there to support the fact that, this isn't a fraudulent thing. It's a risky thing. I mean, it's a high risk transaction. And, depending on the players involved too, it can have some risk to it. There's no getting around that. Due on sale being the biggest, but at the end of the day, to me, it's one of those things where if there is a breach, which I'm not sure there is, I think it's more of a additional contractual right. But even if there is a breach, it's more of an efficient breach scenario.
So I like it, and I've always wondered. And I think I told the story where I was arguing with the big bank lobbyist in front of the committee when we were passing RAP laws. I've wondered, why banks would care, assuming that we don't have a increasing interest rate situation, what have you. And I think it's really just someone checking a box versus them actually caring. So when the insurance is done incorrectly and it shows that the property may have been sold and their borrower is not the primary insured, they're just checking a box and they don't necessarily care. What are y'all's thoughts on that?
I do think that smaller banks care. I think the smaller lenders don't like the idea. Number one, if you're a smaller bank, your money and you have your own portfolio of loans, like a small community bank, I think that you don't like having your money wrapped up at 2 or 3% and allowing a third party to take advantage of that. And so I think they care, and probably justifiably so. These larger banks or servicers, the Fannie Mae, Freddie Mac, they could care less. And I don't know why they would even care. Because, and I say that, I don't know if they care less or not, but it seems to me like if you look at just how these are structured, they're securitized. Do I care? No. And I own probably a 0.00000, 0.3% of, a bunch of these mortgage portfolios, right? I mean, because I'm invested in the market. So all of us have some interest in it and we don't care, right? And that's what you have when you have these large securitized loan portfolios. It's like, who cares? All you care about is paying profit to your investors. And if you're getting money in the door, you're paying profit to your investors. That's what that game's about. Small community banks, I think it's different.
I mean, I can see it being different if there's a big spread in interest rate, but if my borrower sells the subject property and now there's a second person that has to pay that, I consider it to be a good thing versus a negative, assuming that I can't go in there and get my money back and loan it out at a substantially higher interest rate. In that scenario, I understand, but otherwise, why would they care?
Yeah, but most of the investors buying these are buying them in LLCs. A lot of times, single asset LLCs that they could just, in theory, walk away from at any point. And their credit's not damaged. There's no real skin in the game unless they really came out of pocket for improvements and things like that. But if the market shifts down and rents decrease and the property's not cash flowing or they can't utilize it anymore, they could just walk away from it. So to play devil's advocate, I could see why, a bank, now you get a consumer and buyer in there that's assuming the obligations and, has some more skin in the game and, is living there in the property, that type of thing. Then it may be a little bit different. But, if a seller sells to an investor or an LLC, it's like, okay, they just bankrupt the LLC. They can walk away and really not have any, harm done.
You're saying if my buyer sells to an entity,
Or your seller sells to an entity, your seller sells to, if I'm an investor and I come in to buy,
yeah,
and I'm going to do a long-term hold, a rental, and I buy it in an LLC, presumably a single asset LLC, or an LLC that doesn't really have, any other assets, then I could walk away tomorrow and really not have any consequence.
but my borrower still owes me.
Well, yeah, the original borrower still owes you, but now they're out of the house. They don't own it anymore. And by the time they recognize the situation, are they going to, be able to reinstate and bring the loan current? And if you have a deficiency, are they even going to be collectible? I mean, there's a reason why they were trying to sell the house anyway. So I don't know. I just plain devil's advocate.
Yeah. Well, it's one of those, world mysteries that we have. We may never know.
All right. So we have a couple more questions to get to. We'll go ahead and get to those now. If you're just now joining us, this is the Creative Finance Collective. We're taking questions about creative finance. So if you got to, make sure to post them. We'll be around as long as we get questions. If you're watching from Facebook, scan that barcode with your phone at the top of the screen. That takes you to our YouTube channel. You can subscribe there. That's the best place to interact with our content. We'd appreciate it. All right, we got a question. Alan, I think this one's for you, following up on kind of what we were discussing earlier, but it's a Texas question. A lease option with less than 3 years is okay in Texas, right? So we've got a leading question here.
So no, the limit's going to be 180 days. And then after that 180 days, you have to comply with the statute. I think it's 5061 and forward. And that's only if there's an underlying mortgage that's not agreeing to accept payments from the tenant buyer in writing. And if you don't have that, then you're out of compliance. If you don't have that underlying lender, or somehow you do have a lender that's saying, yeah, we'll take payments from the tenant buyer, then you can comply with the statute. It's onerous, and I'm probably not going to assist people in doing that because they're probably going to fail. But strictly speaking, you can. But if there's Wells Fargo lender, Mr. Cooper lender, what have you, they can't be done for longer than 180 days.
All right. Oh, we got a hello from Maryland. We've got watchers from Maryland. That's awesome. Another question, Facebook user. If you get tax benefits, mortgage interest deduction, depreciation, by doing an agreement for sale, why would somebody do a sub-2?
So that's a question from this morning, actually, in follow-up to our show from this morning. So that's a good segue into making sure we hit those questions.
Okay.
So once again, Texas, you can't do agreements for sale or contracts for deed, but in Arizona, we do agreements for sale. In Wisconsin, we do land contracts, and they're executory contracts. So your biggest risk with the executory contract is bankruptcy, because at any point during that contract, a trustee can basically come in and set aside that agreement and basically they have to put the parties back in the status quo, and there's a whole formula for doing that. But they could basically put the parties back in the status quo, set aside the agreement for sale, and take the property as part of the bankruptcy estate and liquidate it. That's the biggest risk for an agreement for sale. Otherwise, it's a good, medium between, kind of happy medium between your traditional wrap and your lease with option, because you do get the, talk to your CPA, but my understanding is you do at least the mortgage interest deduction, you get that, and then the depreciation really depends on the CPA you talk to. I want to go through a couple of the questions this morning and answer them to the extent it sounds like at least some people from the Interim podcast this morning are listening to this afternoon, which is great, because we got at least one question. So basically, for FHA self-performs, and I'll ask Drew and Alan how that would work in Texas and Georgia and Alabama, but I'll talk about Arizona on this one. And honestly, I don't know the answer in Wisconsin, so full disclosure, but in Arizona, I know the answer. If you do a self-performed FHA closing, because a title company or escrow agent won't close, and the seller has a judgment lien on the property, can the seller release that lien through the closing process by declaring the homestead? And the answer used to be in Arizona, yes, until a few years back, we changed our homestead laws to provide. So our homestead laws used to be the judgment liens and non-consensual liens never attached. They weren't liens against homestead. Now they are liens. And in order to release the lien, the title company actually has to record a release of the lien on the basis of homestead. And there's a whole process and procedure depending on how much is being paid to the seller from the closing, how much of the homestead, like 80%. If it's less than 80% of the homestead, then they can just release and declare that the lien is released. If it's more, then they have to give notice to the creditor before they can execute that release. So if you do a self-performed closing and you close outside of escrow, outside of the assistance of a licensed, a title company in Arizona who has the power to release, then no, you can't, and those liens will remain attached to the property, unfortunately. Is that something that, how does the homestead work in both Texas and then Georgia and Alabama?
I'll let Alan go next on this because I have no idea what y'all are talking about when it comes to homestead. For us, it's just a tax thing only. And in Alabama, there's a quirk, but it's nothing like y'all are talking about. So I'll let Alan get to his Texas one, and then we'll go over to Georgia and Alabama.
Interesting. So we have a relatively new statute. I'm horrible on time. Somewhere between 1 and 5 years is new apparently to me. And there's a 30-day release process when there's a filed abstract of judgment out there. It by the Constitution and property code, it does not attach to homestead. However, title company wants that release, and so now Texas has provided that release process. You file an affidavit of homestead, send that to the claimant and the claimant attorney. Wait 30 days. If there's not a controverting affidavit filed, then that's construed as you file a few more documents, and that's construed as a release of that homestead, child support lien, those types of liens. So in theory, that would be good, but I like the old law because there was a case out of Tarrant County. It was Tarrant County Bank being sued because they didn't release their lien against a homestead, and they lost and they got hurt. So I would be able to just send that case out to all the claimants, and we were actually able to get a release because they didn't want to suffer any damages. Now they're learning, go get your own release, take your 30 days. And so it slowed us down a little bit, but I guess at least there's certainty in regard to that release now. So we've got a statute on it.
So, Drew, is there no protection from creditors in the equity of your primary residence in Georgia?
So you do in a bankruptcy context, but outside of bankruptcy, I mean, if there's a judgment on your property, they obviously can go and levy, and they can begin a judicial foreclosure proceeding. Now, they can't take your equity, right? But if you owe them money, they're going to get what they're owed. In Alabama, the homestead is kind of weird because all deeds have to state the marital status of the grantor, which is obviously the seller on a sales side, but it's also the borrower on the borrowing side. And the spouse of a homestead must join in on any conveyance, which includes mortgages. And we recently had a case in the last couple of years where I think it was Wells Fargo. They failed to get the wife to sign on to the mortgage. And so obviously she sued because, the mortgage was defective. And so the court had to value her homestead, right, exemption. And the value of the homestead was $2,500. So Wells Fargo wrongfully foreclosed because she had failed to sign on to the deed. However, we're not going to reverse the foreclosure. We're just going to pay the wife the value of her homestead, which was a whopping $2,500.
Holy cow.
Wow.
I think our homestead is up to 400,000 now.
Yeah. So
Yeah. So in a bankruptcy context, you are able to set aside certain things. But again, if there's a judgment and it's filed and you owe the money, I mean, we see this with FIFAs fairly regular. Of course, they don't sell the house, but I mean, they absolutely will send the sheriff to go, haul things out of your house on a sheriff's sale. But yeah, we don't have all these weird protections.
Mm.
I say weird because, Georgia and Alabama are similar in that respect, is that, if you owe something, you need to pay it. And if not, they're going to levy what you have to pay it.
Sean, we had a clarifying question going to
Yeah.
your original question. What does self-performing actually entail? I've never had to do one before. My title company can do FHA sub-2s.
Well, if your title company can do FHA sub-2s, then that's awesome. Keep using them. But in Arizona, pretty much as far as I'm aware, actually there's one. So Scott Horn will do them here in Arizona, and he has a title company here in Arizona. So he's not on with us, but I'll give him a plug for his title company. But in Arizona, there's really no other title companies that will do it. So the parties have resorted to basically, having their legal documents drawn up, prepared. Then they go and they have the parties execute, record the documents, close the transaction that way. And then after closing, if the buyer wants it, they can go and approach a title company and get title insurance, but it closes completely outside of escrow.
All right. One other question, going back to our earlier discussion, we had a YouTube question. Efficient breach, is that a primary legal defense strategy? Not sure what they mean.
Yeah, I don't think it's a defense, because basically an efficient breach isn't really a defense per se. It's a legal theory that basically avoids the criminalization of breaching contracts, if you will, or the illegality of breaching contracts. It's basically renders it what it is, which is a breach. And so the doctrine of efficient breach basically provides that there are times where it makes sense to breach your contract and suffer the consequences, because it's cheaper to do that than it is to actually perform under the contract.
Right. Sean, all right. So do we have why don't you give us our next question that we had from this morning?
Yeah. So as a contingency for a due on sale clause, can we put a clause into our purchase contract that the property will be deeded back to the seller and that the transaction will be restructured as an agreement for sale or lease with option to purchase? Basically that, it provides a contingency in the contract that the seller agrees that they'll cooperate to, allow for the unwinding of the transaction and restructuring. My answer is, yeah, you can put something like that in the contract. I mean, you can put a number of things in the contract as long as they're legal and, don't require, criminal or illegal conduct or conduct that would violate the law. But, And that's not a bad addendum because it helps, or provision, it helps set up and have this conversation with the seller, like what happens if the due on sale clause is called, and then hopefully the parties are prepared for it. The thing is, the seller still has to cooperate, right? If the due on sale is called 6 months down the road and you go back to the seller, you still have to have a cooperative seller that's agreeable to basically unwinding and restructuring the transaction.
What if you sign off on that deed in lieu of foreclosure at time of closing? What are your thoughts on that?
The deed in lieu of foreclosure, well, so the deed in lieu of foreclosure is people use it as a security for the seller in the event that the buyer breaches. I won't assist with those. I don't like pre-signed deed in lieu of foreclosures because our statutes contemplate that it must be signed at the time that there's been a breach. However, in the investor world, right, if I'm the investor and I give the seller a deed in lieu of foreclosure, I guess at the end of the day, the only one that can object to it is the investor. But as an investor selling, I wouldn't take a deed in lieu from say an end buyer, because that end buyer could object and that type of thing. I don't like them for the reason already stated, which is the statutes contemplate that signed at the time of foreclosure. And the other reason I don't like it is because I think the seller thinks that they're getting something that they're not getting, or may not. They may get it, they may not get it, but they're not getting that disclosure, which is, hey, before you use this, you better pull a title report and make sure that there's nothing out there, because you may need to go through the standard foreclosure process. So I'm just not a big fan of the deed in lieu. What's your thought, Alan?
So I agree 100%. A, I'm not a fan of it, and B, they're trickling into the system. People are asking for them. I don't consider them to be enforceable. I would call them voidable, I guess. If the buyer wanted to dispute the enforceability of that instrument, I think they would win. So when people force me to draft one up with my loan documents, I've got a big old disclosure that says, hey, by the way, this is not enforceable potentially. And I make both buyer and seller sign off on that. So I'm essentially alerting the buyer to their ability to avoid that document. And so I'll have investors, real estate agents, and people involved in the transaction tell me, well, no, you don't need to advise the buyer that it's potentially voidable. Just let the seller know, but don't advertise to the buyer. And my answer as an old lawyer is, take a hike. I'm telling everyone involved in this thing.
Yeah.
So who, on the deed in lieu of foreclosure, if there's a loan servicer in place, does the deed in lieu of foreclosure go to the loan servicer, or does it go to the seller?
Goes to the seller with them wearing their lender hat.
And so literally, if the seller wanted to, and let's say the seller had seller's remorse, the seller could literally walk into the county recorder's office, record the thing 2 weeks after closing, because they're like, I didn't like this deal anyway, so I'm taking it back.
If they have the combination to my safe.
Oh, you hold it. So you
Absolutely.
hold the deed in lieu. Okay.
What do you do about the dating on those? So I would make a distinction between deeds in lieu, which I've done for clients before. And you're right, you always run title first to make sure there's no intervening matters, because in Georgia and Alabama, which I'm sure elsewhere, the deed in lieu is not like a foreclosure. It's not going to clear encumbrances, right? You take it subject to any intervening matters because it is in fact a deed. And that, again, I've done it for, private lenders that, they worked it out with their borrower that this is the right way to go. It saves everyone the hassle and trouble of foreclosure. And again, title was clean. Versus a pocket deed, which country folk love, right? Granddaddy stuck this deed in his desk, 15 years ago and said, when he dies, record it. And I despise pocket deeds, right? So on these deed in lieu, since they're signed, during the at the time of the initial conveyance, what is the effective date of those deeds? Because they should be a present tense conveyance back to your seller. And if you stick it in your safe for 6 months, a year, 2 years, now all of a sudden you're filing a deed that may be literally years old, which of course from a title perspective, that obviously raises some yellow flags. And deeds are supposed to be present tense conveyances. They're valid, right, as between the parties, even if not recorded, right? But they're supposed to be recorded. So how do y'all get around that? And same with you. I won't do a deed in lieu if it's intended to be a pocket deed. Right. I'll do a deed in lieu again if you're a lender and this is the way that you want to work it out. But if y'all are setting this up as some kind of insurance, no, thank you.
And that's what they're doing. And I haven't been told, hey, we have a default 60 days. Loan servicer has the evidence here. Now go record that deed in lieu. If it does occur, I'm going to circle folks back to loss mitigation efforts. Let's see what's going on. Maybe even get a fresh deed in lieu from them. So I don't know what Scared Alan's going to do whenever I'm told to record. And that pocket deed that you're talking about, we had a situation exactly like you said. Grandpa conveyed the property to grandson. It was only 3 years old, and the underwriter said we need evidence of acceptance from the grandson at the time of the dating and conveyance. And I said, what do you need as evidence for that? We're trying to close a file over here. And they said they don't know, just need evidence.
That sounds about right. But I said that's the thing is they are present tense conveyances, and so now you've got this weird mismatch in the records that I said I had one. It was a 15-year gap. And I was just like, no, I have no interest in assisting with this transaction, and turn them away.
I suggested to the underwriter just an affidavit from the grantee that says I accepted this conveyance at time of dating and have agreed to it all time since, and I'm okay with recording this. And it worked once previously.
Well, it not exactly the same as what you guys are talking about, but I'll share a story of dealing with the whole acceptance issue and how title companies kind of look at it. I had a client referred to me for a consultation because they had a title issue. The wife had died, and they held title as joint tenants, not joint tenants, tenants in common. So it wasn't joint tenants with right of survivorship. It was tenants in common. And so the husband was like a week away from closing, and title's like, no, you can't close. The wife's dead. Nobody's probated her estate. And the husband's like, I don't want to have to probate. It's going to take time, whatever. So they consulted with me. And the husband brings in this binder of estate plan documents and sets it on, the conference room table and says, I don't understand. We went and did this estate plan. Why do I need to do a probate? I put a trust in place and the whole thing. And so I'm like, yeah, that is weird. So I'm looking through the estate plan, binder, and I get to the very last page, and in plastic is the original deed that never was recorded. And so I pulled it out, and it was like 10 years old, and I'm like, shoot. And so I kind of told him, I'm like, okay, we're going to take this title company. If they ever ask you, you say that it was, conveyed and accepted to you at the time that you did your estate plan, and your wife accepted it too, and the trust accepted it. Like, keep using the word accept over and over again. And so finally we convinced the title company to close the transaction using that old warranty deed. But they were giving us, the inquiry, they were, so tell us where was this deed? What happened? And, we had to go through the whole thing. And I think when I explained, look, he brought his original estate plan documents to me and it was in the back, I think they felt more comfortable once I kind of broke it down or whatever. But yeah, you have to show that acceptance for an unrecorded deed.
Yeah.
And we're talking about probate. I just got a file closed on Monday. And months ago, we did probate. And by we did probate, she meant we filed the petition, which obviously is not, finishing probate, and at least in Georgia, having letters testamentary issued, which, we then have to follow the terms of the will. She had just filed the petition and thought she was done, and so did her real estate agent. And, we wound up delaying the closing for over a month for them to actually finish the petition and the process and get letters issued. So I just want to throw that out there that, if you're in the, investment wholesaling space and you've got a deceased seller, you might need to take a look at your time frame, because it's not going to be a couple of weeks if they're not actually ready, and they may not be aware that they're not actually ready. So just keep that in mind.
All right, we have a couple other questions from Facebook users. We've got about 7 minutes or so here, so we'll try to get to these quick. Got another solar panel question. I don't think we'll ever stop getting solar panel questions. Are there any issues taking over solar panel mortgage? Seems like more properties have solar panels nowadays. I would say more properties have solar panel leases nowadays. I don't know how often we're seeing solar panel mortgages, but any issues taking those? That might be easier to take over than the lease.
Yeah, we don't mess with any qualified assumption of those rental obligations or payment obligations. We do let them take over sub 2 and continue paying them. And we're also I'm kind of running an experiment. When the seller is in a distressed situation and the solar panel amount is causing the deal to not be viable for the investor, we're letting the seller say, yeah, move those over to Schedule B, letting the buyer say, I'm not going to continue paying these. They have the right to come get their product. I may have to repair a roof or something of that nature, but I'm not paying the $47,000 for the solar panels. And then seeing where that goes, because I think where it's going to go is nowhere. They're not going to come and get their panels. They're probably not going to be pursuing distressed seller. If they do, they're going to get nothing, at least here in Texas. So we're setting those things up. But we do let people close all the time and continue paying them.
All right. Here's a short sale question. Sean, I think you'll like this one. If I negotiate a short sale as a DBA for my company and then have my company buy the property, does that violate the arm's length agreement?
It's been so long, honestly, since I've reviewed one of those that
You'd have to see the arm's length agreement.
Yeah,
right?
I'd have to see the arm's length. It's, back in the day, I could have told you right off the top of my head, because I knew all the arm's length agreements from all the lenders and what the terms were and stuff. But it's been so long, I don't remember.
Well, it's a little bit like language on due on sale clause. It can vary depending on the lender, right?
And it does, yeah, it does. And there were about 4 or 5 out there back in the day that you could, know you would receive one of those. And yeah, unfortunately, I just don't remember. It's been so long.
Yeah, on that question, that's one you'd want to get the arm's length transaction and talk with a lawyer in your state, have them review it, make sure you're good to go. All right, guys, we've gone through pretty much all of our questions.
Yeah, I've got one.
Oh, you got one.
Oh, all right.
What is
Well, we'll see if it's a question. So a little bit of an update. Sean, you scared the bejeebus out of me when you said
he's good at that.
on these land trusts that we're doing where the grantors and it's revocable, and so the grantor can come back and revoke, and settlers and grantors may end up having some liability associated with that trust or property of the trust.
Yeah.
Well, you scared me. So I got with trust attorney and have asked them the question, but what happens if instead of the seller placing the property into a trust and then we assign the beneficiary interest, what if the sale occurs and then we put the property into a trust with the buyers as the grantors or settlers of that trust? Does that avoid our problem that we have?
So if the buyer on the purchase contract is the trust and that the grantor of the trust,
No, the buyer buys and then the
buyer
property
buys.
goes into a trust.
But in that case, though, wouldn't the bank see the warranty deed from seller to buyer and consider that due on sale?
So if they see the conveyance, but usually what we're seeing is the insurance being set up as the triggering cause. So
Oh.
they wouldn't see that intervening transaction.
You know, my preference would be this, and that would work too, because it would be on the insurance certificate as the trust.
Yeah.
But what you can do is the buyer can be the grantor of the trust. So they set up the trust on the front end of the transaction, the buyer. They're the grantor, their LLC is the beneficiary. They open a bank account, they fund it with $100, okay? And it's whatever the property address is, 8523 Mulberry Drive Trust. Okay. They fund it with $100. They name, because who your trustee is doesn't matter from a liability perspective. They name the seller as the trustee of the trust. And so then you make that trust the buyer under the purchase contract with the seller as the trustee. And then the warranty deed will be from seller to seller as trustee of 8523 Mulberry Drive Trust. The deed of trust will list the trustor as the seller as trustee of seller as trustee of the 8523 Mulberry Trust. The seller then would be listed as the beneficiary of the deed of trust. And then as part of closing, the seller executes a resignation of trusteeship, and the trust already provides that the successor trustee is the buyer. Then, it's not a Garm St. Germain transfer. It's not a Garm St. Germain compliant trust, but nevertheless, to the extent you wanted anonymity on all the documents, you've created it.
So that puts you back into a extremely similar situation where seller's grantor, seller's beneficiary, and then you're assigning the beneficiary rights. You're creating that trust via the buyer and letting them step into the shoes as the actual buyer. Seller sells to trust.
Yes, seller, and then the seller resigns as trustee immediately upon closing of the sale. Now, the risk you run with all of this, is, and you guys from a title perspective can figure out how you want to deal with this. The risk you run is the seller fraudulently in the future fraudulently creates a trust document showing them as having full power over everything as trustee and beneficiary and the whole thing. And then they go and sell the property out from under the land trust buyer. Do you see what I'm saying? Like, there's nothing stopping them from fraudulently creating an 8523 Mulberry Drive trust, getting it notarized by some bank notary somewhere who all they're caring about is notarizing the signature. They don't know that there's another Mulberry Trust out there. And then they present that to a title company and sell the property.
So you're like
I have the perfect example on that. And this was in Bibb County, Georgia. There were two LLCs. One was an Alabama LLC and the other was a Georgia LLC. And they were the exact same name, other than an Alabama limited liability company and a Georgia limited liability company. And the good news is the two owners knew each other. And so I was able to get them, because they don't always write, right? Because lawyers don't always write an Alabama LLC or a Georgia LLC. They just write whatever LLC. And I was very fortunate that the two guys knew each other and we all got on the phone call together, and I was able to figure out who owned which houses. going forward. And we made sure that on our deeds that it, specifies Georgia versus Alabama. So, I mean, it's not just trusts, it's any kind of entity. If people aren't, crossing their T's and dotting their I's, it's an issue. But you raise a bigger point that I brought up with my underwriters. When you're dealing with LLCs or any kind of entity, I mean, you're at their mercy. And I hate it. And I don't really know of a good way around it, because you can achieve anonymity in some states, even with entities, not just trusts, but you're not required to disclose who members or officers are. And so that's definitely a real risk.
So Sean again has been the waiter that brings a nice 8-ounce filet mignon and says eat dinner, but then takes it back away and says,
Be very careful. Yeah.
Yeah, I had a good idea to, the whole, but I think you run that same risk, Alan, with the I guess to your point, if you're on the back end and you convey the property from the buyer, the LLC buyer, to a land trust set up by that LLC buyer, then you're safer, you're cleaner that way as far as the risk.
easier to insure also.
Easier to insure.
A title insure. Easy.
Right. Easier to title insure. Yeah. So I think that's cleaner if as far as that goes, as far as, the insurance and things like that. But I don't know, it's land trusts are interesting because there's a lot of people out there that swear by them and are out there, preaching them and getting people to do them. And they're doing it
because
the
they're
one that definitely you don't want to do.
Yeah, because they're making more money on it, is what I've heard.
Well, they're
by setting up the
right?
trust.
They're selling no attorneys aren't really doing it. It's non-attorneys who are running around offering their land trust packages for $5-10 grand or whatever, and teaching people how to do it. But what they're
perfect
doing
anonymity until you're in Georgia and we require you to file a certificate of trust. And guess what the certificate of trust has to state?
Yeah.
Has to state who the grantors are, who's the trustee, who's the successor trustees, and all of a sudden I have just blown your land trust up because your name is all over half these documents.
Yeah, we don't do that in Arizona, but we have to disclose the names of the beneficiaries and their addresses. But the problem is, Drew, is what we're seeing is what is happening is they're creating these land trusts and they're having the seller sign the land trust as grantor. They then are having the seller convey the property into the land trust, and then the closing isn't your standard, seller to buyer closing. We're changing the beneficial ownership of the land trust to the buyer. And then swapping out trustees and the whole thing. But the law is very clear in Arizona, Wisconsin, and I think Texas is the same way in a lot of other states, is that a revocable trust is not an asset protection vehicle. And a revocable trust and the grantor, in the eyes of the law, are one and the same. And there's statutes that basically say a revocable trust is liable for the debts and obligations of the grantor or the settler for the lifetime of the grantor or settler. So you do this, buyer buys it, they think, oh, great, I did this land trust transaction, it's all good. And seller is out driving around 2 weeks after the closing and, God forbid, kills or seriously injures somebody, and they end up with, a multi-million-dollar claim against the seller. Well, guess what? They have a multi-million-dollar claim against the trust and a multi-million-dollar claim against the property.
Absolutely. And then that's because they set it up as a grantor trust. If they set it up as a non-grantor trust, which is not necessarily the same thing as irrevocable, although they're very similar and they get overlapped. I used to do high net worth estate planning when I was younger, right? So, the way that you can finagle these things is very important and very, complex. But yeah, if it's a revocable trust, you're done for if any of your grantors get in trouble.
Yes. So we might have to talk offline, Drew, about this.
And me.
Go ahead, Alan.
And me.
Yes.
Okay.
Yes.
They'll come in.
You
Yeah,
will be
I had a
included.
lot of fun with those estates. There were
I-
several tens of millions, and it was fun figuring out how to stack and structure. Of course, ours are for estate planning purposes, not for like
Right.
land holdings, but
Right.
there's a lot of fun ways that you can design things to get what you need.
Well, let's I'll circulate an email here between you and Alan and me and Andy or anybody else that wants to attend. Basically, I'm curious what you have to say on that, because the way these trusts are being drafted now,
Trash.
that issue is
It's
prevalent.
not working.
But if we could figure something out, that'd be awesome.
All right. Well, we've had a lot of good questions, good discussions, and ever since Alan brought up a filet mignon, I think it's time for dinner. So with that, thanks guys for being on the show. We'll see you next week.
All right, we'll
Thank
talk to
you.
you.
Everyone.
Okay, bye.